On behalf of everybody here,
Thank you.
job well done.
Thank you.
I also want to take an opportunity to ask the first question, if I may. Just when it went back to the standard unit or standard insurable unit description, so it has to be filed at land titles. But the question I'd like to ask is, if it's passed by board resolution,
Yeah.
does it get registered, not get registered until it's been ratified by the owners at the general meeting?
Yes.
Okay.
Because I don't think, again, the way I read it, and then maybe Todd and Hugh read it differently, I think it's just the first step in the process, and I don't think it becomes the description until it's been ratified. So that, I would read it that way.
I'd register it.
Yeah, I would register because I think the idea is a consumer protection or notification aspect. And I think it's going to be a really important document on the purchase and sale, so that when lawyers acting for purchasers are giving instructions or explaining what they have to carry insurance for, they can show them that document and say, where does your unit better than the standard? Like, go through each item and say, would you have better bathroom faucets? Do you have better paint? Do you have better flooring? Do you have better cabinetry? Where are you better than the standard? Make sure you have insurance to cover that.
But when you, simply at a board resolution, you registered a land titles, you're telling the world that it is the description, but it has not been ratified yet.
Yeah. But I think you can change it too.
Well, you can always change it.
Yeah.
It's a point that's taken, but I would err on the side of just getting it registered. If I could address one point on this standard unit description, when you've got the old corporation and you don't really know what was done or it's complicated, you don't have to go back and figure it out. Don't waste the time. Focus on what the board or the owners feel it should be. And you're not telling people you can't have coverage for upgrades. What you're telling people is, here is what the insurance the insurance policy, the corporation will cover you for. If you are below that, then make sure you've protected yourself under your own unit owner insurance policy. So this solves a lot of problems that used to exist of, well, what was the base package back in 1970? You can now determine it for yourself. And
Yeah.
I think it's a good thing.
And I'll jump in on that. And a great example of that is the older condos, maybe no, but the base unit, there was no dishwashers. But after the past 35, 40 years, everybody has a dishwasher now. Owners can now say, okay, a standard appliance package is standard, is part of the base.
All right, sir, go ahead.
Okay, hello there. Just a quick question on the caveats. The tip here is be certain to pass a board resolution to send for the issuance of a caveat. Does that need to, our accountant typically manages people who are in arrears and sending them notices and blah, blah, blah. Do we have to, as a board, pass the resolution before he initiates the caveat, or can...
I like saying yes, and the reason is because the caveat right gives you the ability to foreclose on someone's home. I think the board should be treating that very seriously.
Okay.
And taking the step to decide, you know what, we are sending this to for collections and including foreclosure, I think is a reasonable step for the board to take, given how serious the remedy can be. Now, I don't think you put the person's name. We suggest instead you say legal unit blank.
Right.
Yeah.
Okay.
What about a blanket resolution?
I don't like
You?
the blanket resolutions either. I prefer an individual per item. That's our practice, at least at our office.
Okay, thank you very much.
Go
So I just want to clarify the rental deposits. So if rental deposits were collected prior to January 1st and they are less than $1,000, they stand.
Yes.
Okay, perfect. Thank you. They're like grandfathered in.
Hello, thank you. I just wanted to clarify reserve fund studies. Can they come out of the reserve fund or not?
Can the payment for them come out?
Yes.
Yes.
I think
Specifically,
they
they can now.
Where does it say that in the Act, please?
It's not in the Act, it's in, actually it is in the Act. It's in section 38.
That's a new,
And that is effective as of January 1st?
that was a,
That addition, That was in, I think, just give me 1 second, I've color coded this. That was effective January 1st, 2020.
So section 38, thank you.
You bet.
Go ahead, Morris.
In regards to the standard insurable unit description, back in 2000, our condominium complex voted to have our windows owner's responsibility, windows and doors. How do we describe that in the standard unit definition, or do we?
No, that's one of the reasons, the great examples of why we should have standard insurable unit, why this is such a great concept, is so that when you're preparing that, the person who's preparing it should be reviewing your condo plan and your obligations, so that you can say, hey, this is what is included and this is what is not included. And if the corporation is saying that's something that unit owner must carry coverage for, fine. Practically speaking, your insurance costs are not going to change that much if you're responsible for insuring the windows and doors. That's different than a responsibility to repair, maintain, and replace.
Okay, thank you.
Hello.
Go ahead, sir.
I want to clarify about the insurance deductible, charging it back to the owner, because it says if it originates in the unit's owner, you can charge it back. So if, for example, if the sink backs up and it floods 2-3 floors, is that, you can charge that deductible back to that owner? It's not necessarily his fault, but
Right. And
it did originate from him, but it's not his fault either.
So there are limited defenses to an owner. We talked about a defect in the construction of the unit. If the damage is attributable to some act or omission on the corporation, so let's say, for example, the corporation hasn't cleaned the pipes for years, and there's been a tremendous amount of grease buildup and other things, I think you've got a legitimate defense as an owner to say, wait a minute, you know, it backed up because you guys didn't do what you were supposed to do. And also any normal structural deterioration of the common property, other than property that the owner was responsible to repair or maintain. So if it's normal wear and tear, that's the responsibility of the corporation, the owner will not be responsible too. So what's going to happen over the years, there will be no doubt litigation, law cases, where courts will start to interpret and put some additional meat on these sections. But there are, in the example you gave, the owner may have some legitimate defense to that.
So in building on that, if you're on a board and you got a backup
Yeah,
that
we
is
have that,
flooded
so-
off 3 units, and you send in a plumber, the first thing that I would do is I want the plumber to identify what the cause of that backup is. Because you might have up to a $50,000 hinging on it. Because if that backup happened down, you know, underneath, you know, if it's the standard stuff we typically see, below the floorboard. So in the pipes that are lower on, if the backup happens there because of grease, the problem didn't originate in the unit. It happened there.
Yeah,
but
but-
if the backup happened because the trap was full of rice, right, then it originated in the unit. So if you're instructing someone to go in that situation, you should be instructing your plumber, I need to know what happened. Go in and figure this out if you can, because you might have up to $50,000 hinging on it.
Yeah. And I think just to make you can charge it back to the owner if your bylaws allow you to do it. So if you don't have the right bylaw language, you can't treat it as a contribution. You'll have to. No.
Sorry, what you're talking the difference between charging it back as a contribution versus recovering it. Maybe we'll just kind of
Right.
clarify
So
that.
chasing in small claims, right? If you want to treat it as a contribution, you still need the bylaw language. Yeah.
Okay, thank you.
Okay, go ahead.
When we talk about the board investigating, you know, an offense by an owner and needing to gather evidence that said offense occurred before sending a proposed sanction, is it appropriate to use your video security system to prove such offenses? We have a number of residents in our building that are constantly saying, check the video, I think it was so-and-so who left the garbage door open or something like that.
So the challenge with video is, yeah, if you have video which proves something, and of course you use it. The challenge with a lot of corporations' video is that they haven't done it properly. So we were involved with a matter years ago where someone was vandalizing the elevator. And so they installed video cameras in the elevator, and they had a unit owner on video repeatedly defacing and damaging the elevator. And so they charged him for this. They sanctioned him and did other things. He went and complained to the privacy commissioner. And so they went through a process where they looked at whether or not they had complied with privacy regulations in regards to disclosure, identification of the fact that, yes, you're under surveillance. Do they have a video manual? All of these types of things. And he didn't like the answer, and he went and appealed it. And so then we had to get involved and assist them for something where he was flat out totally wrong, but he took everyone through that process. And while his complaints were dismissed, it cost a whole bunch of time and effort because actually they hadn't paid any attention to their obligations, their privacy obligations in regards to video systems. So just use that question, and the answer is yes, you can use it, but circle back and make sure that your video system, you've actually taken a look at the obligations for installing such a system pursuant to your privacy laws in Alberta. And you'll find information on the website for the privacy commissioner. And in the event you still don't know, they're a great resource to actually phone up, and they'll walk you through it.
And
I'll
should
jump-
should we also have it in our bylaws or rules?
Your privacy policies, not in your bylaws. It should be a standalone document. But I'm going to jump in as well and remember that in my experience recently, in the last year or two, we've had a number of clients come in where they found something on camera. You still need the board resolution to charge it back, okay? And this is part of your investigation. But it also gives you a chance to cool down. Because often you find something on the camera and you're really charged up, I got him, and it results in correspondence, letters, emails, texts to the person involved that are unhelpful later on if we're trying to enforce or deal with the problem because they're far too aggressive, far too emotional. So if you catch it, do your best, separate the emotion from the issue, bring it to the next board meeting, handle it that way.
All right, go ahead.
Hi, this is a question with regard to rentals. The cheat sheet that Service Alberta posted with regard to condominium rentals says that the Act doesn't allow corporations to create bylaws that prevent owners from renting their condominium unit.
Correct.
We would like to restrict, or we're considering restricting owners using their units as Airbnb.
Yep, you can.
We can do that?
Well,
Does that fall under the normal?
it depends who you ask. So at a very high level, because I mean, we did a CCI one
Okay.
a year plus ago, and I spent a whole lunch hour talking about this. But to condense it into 30 seconds, in BC and Ontario, where they've been dealing with this for far longer than we have, the law is more developed.
Okay.
And specifically, the conclusions there are that you can restrict these types of things as long as it's clearly set out in the bylaws. And in their legislation, and specifically in BC, there was case law that looked at whether or not an Airbnb situation or your sharing economy was a short-term rental. And whether it was captured by some of the rental issues in their legislation, similar to our Section 53. And their answer was it actually wasn't a lease or a rental. It was a license. And so it's a different set of principles. The challenge that we have here is that we do not have clear case law on this.
Okay.
There is one case that is winding its way through the courts as we speak. There was an interim decision on an injunction that may provide some, that you might see become the basis of the decision, but we're looking for greater clarity. What I personally do right now is I will put it in the bylaws. I make it very clear that it's, short-term rentals are not allowed. I define what the amount is, but right now it's subject to where the court ultimately goes. I'm a fan of, if you want to restrict it, get it in your bylaws. Don't try to rely upon the single-family residential clause solely. That might be successful, but I think there's risk with that.
Okay.
So if you want to prevent it, get in your bylaws and be very, very clear as to what is allowed and what is not.
Okay. Thank you, Todd.
All right, our last two questions here.
Oh, thank you. The new legislation states that the corporation may require an owner to purchase corporation deductible insurance. I've attended several seminars, and when they talk about that issue, they refer it to as this corporation deductible insurance. If I was to phone up my insurance broker and say, I need to buy some of this coverage, they probably wouldn't know what you're talking about.
Hang up and call
Okay.
someone else.
No,
they
some,
will.
No, they don't.
No, they don't. No, they don't.
Some do, some haven't. I've had half of the brokers where I've received calls on this, and it depends who the broker you're talking to. There's some brokers that are involved with CCI. You call them up, they know exactly what you're talking to. But I've had multiple clients who have called their broker, and they're being told, yes, you have it, and they're pointing to special assessment insurance or something totally different. So it really depends upon your broker. So if you're contacting your broker, you need to say, I need to see that I have coverage or deductible coverage for the condominium corporation's deduction, and I want you to show it to me in my policy or in my statement of my policy terms. I want to see it, because I've seen already brokers who say, don't worry, you got it, and then when they've done further investigation, they actually don't.
Well, it's been implied that this is a standalone insurance coverage policy. It isn't. It's part of a package policy. And I think most owners here would know what a unit package policy is. They may not know the term insurance deductible insurance. And I believe that that regulation 60.2 should be written more clearly, where it actually, that should change to the purchase of a policy that the insurance industry refers to as a owner's condominium package. It's a lot clearer. That coverage that you had mentioned, deductible insurance, it is part of a package policy.
Not in every policy.
It's in every policy. Every standard condominium policy has that
I can tell you
coverage.
the policy I purchased, it was an add-on. It cost me $60.
The only difference would be this 50,000 deductible. Some policies may have a limit because
Right.
that coverage is supposed to be
Some
buying.
policies include it,
Pardon
some
me?
don't. Some policies include it, some don't. So if you're talking to your broker and they don't understand what you're talking about, like if they're based out of province, I would ask to speak to somebody else. But you can also ask them to speak to the corporation's broker. And when the brokers talk to brokers, they're often able to sort it out. But it's not standard in every policy. You have to make sure that what you're getting is right. And I think you're right to ask the questions, because right now we have too much uncertainty. And we have, the industry will eventually settle, but we're in a period of a bit of chaos right now trying to find the right coverage. So I think it's right to have the discussions, but sometimes it is an optional add-on.
Just one other point.
I'm sorry, Ted, we're going to have to.
Can I, this is a short one. This is on this absolute liability.
Okay.
If you are in a condo, whether it's a bare land or it's an apartment-style condominium, and you have a rupture in the wall, which damages your unit plus other units, you had mentioned that example. What policy should respond?
It depends.
And who would pay the deductible? Because this is something that an owner would not have any control over.
It depends, right? So even that question right there, so you have a pipe rupturing in the wall. So the first thing you got to do is you got to figure out whether or not that this occurred within the unit or not. And depending on what wall or what definition you have or your boundary between your common property and your unit, it might be one or the other. So your first step is to find out if it actually is the unit. Now let's assume for a second that this happened within the unit. The loss originated in the unit. The owner is responsible, period. So why do we see this change? We see this change because, and you heard it here first, we're facing a crisis, if you don't know this yet, on insurance in this province for condominiums. And costs are going through the roof and have been going through the roof, and corporations have been absolutely been hammered typically by water loss claims. And so this was one tool that was done to try to help mitigate some of the costs and expenses that corporations were facing as they dealt with things such as water claims. Because you can shift some of that burden to owners who can obtain coverage for the deductible a lot easier.
Just back to your point, as Todd said, there's going to be massive litigation over whether that pipe burst because of something the owner did or whether it was normal wear and tear, which is one of those exclusions. I think there will be insurance lawyers who can book the next 10 years on that specific issue. But it's,
Well, I
I'm
can-
just glad to see somebody's dug down deep in those details.
I can understand the example that was used with the bathtub, okay? That's something that's ridiculous, okay? So the condo owner should be responsible for that. You caused the damage, you pay the deductible. But it's within, and I'm thinking about an apartment-style condominium where the owner owns just the space within that unit. So if there's a break in a wall, within the wall, how can an owner be responsible for
They're
even
not.
paying the deductible?
No, they're not. If it happens in the common property, they're not.
Okay,
Two really, hopefully very short questions back on the insurance again. Roberto mentioned one of them. You know, the deductible is $10,000. I flood my bathtub and wreck a couple of units. It's $7,000 damage, which doesn't hit the $10,000. Could you write it into your bylaws that the person is, responsible to whatever the damage is or the deductible, whichever is greater?
No.
No?
And the reason is because there's an obligation to provide insurance. So the only thing that the owner can be responsible for is the deductible, or there's an opening for intentional acts.
I
Okay.
disagree. I think you can. With
You
the
could
idea
try
that
it, I suppose.
the corporation is self-insuring at that point. So
Right, because we're paying the $7,000 because
So I take
I'm
the
sure you
position
kind
you
of
can.
fall through the
I
crack.
think you can too.
Sorry, are we talking about something that's over the deductible amount?
No, under.
All right, then I agree.
Under, oh yeah, so, and so
Yes.
then, on the other hand, if, say, the damage was $12,000 and
Yeah.
our deductible's
If it-
10, can we go after the owner for that 10,000 and then just pay the other 2,000 out of our
Yes.
pocket?
Yes.
Okay, that's the question.
all right. Thank you so much for everybody for your patience and all your questions tonight.